an escape from the extreme heat or cold weather in Delhi. And as the elections come near, that in the march of technology, we should not leave any citizen behind. Because there is an internet divide. The government of Karnataka has sanctioned laptops for all government leaders and judicial personnel who focused on work-life balance and stress management. The capacity to manage stress is significant. As Chief Justice of India, I see so many lawyers and litigants crossing the line when they speak to us in the court. The answer when these litigants cross the line is not to. I had a little pain in the back, so all that I did was I placed my elbows in my armchair in the court and I just shifted my position in the chair. That video was doctored so as to delete that part of what followed thereafter. And there was a big amount of social media comment that the chief... ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ ಮಾತು. ನನ್ನ ಋತುಪೂರ್ವಕ ಶುಭಾಶಯಗಳು. ಕರ್ನಾಟಕ ರಾಜಧಾನಿಯಾದ ಈ ಸುಂದರ ಬೆಂಗಳೂರು ನಗರಕ್ಕೆ ಭೇಟಿ ನೀಡಿ ಮತ್ತೊಮ್ಮೆ ನಿಮ್ಮೆಲ್ಲರ ನಡುವೆ ಬಂದಿರುವುದು ಬಹಳ ಸಂತೋಷವಾಗಿದೆ. I share a close affinity with the state of Karnataka and the charming city of Bangalore. I've had the privilege of visiting the city several times. I think I'm almost a veteran in this auditorium. I've been here 4 times before at least, and this is my 5th visit here. Bangalore often serves as an escape from the extreme heat or cold weather in Delhi. And as the elections come near, the heat tends to increase in Delhi naturally. I believe that the cliche about the famous Bangalore weather is also symbolic of its people. Just like the weather, the people of Bangalore are measured, pleasant, and extremely hospitable. I see that reflection in each of my 3 personally friendly colleagues who I have a great deal in common with. It is therefore my privilege to inaugurate the 21st Biennial State-Level Conference of Judicial Officers on the topical theme, Equity and Excellence for a Futuristic Judiciary. As judges of the High Court and the Supreme Court, we are often perceived to be detached from the realities in our district courts. The conversation about judicial reforms and issues affecting our judges is often limited to a dialogue between the Supreme Court and the High Courts. Conferences such as this serve as a departure from this tendency, recognizing that it is our district judges who are the first point of contact for our citizens. As the previous speaker said, recently the Supreme Court, in collaboration with the Gujarat High Court, organized the All India District Judges Conference in Kutch. And we are planning another conference for district judges, almost 1,000 district judges in Delhi as well. The topic for this conference and the theme is equity and excellence for a futuristic judiciary. What do we mean by futuristic? By futuristic, we mean a modern judiciary, but above all, a judiciary which also can meet the challenges of our times. And those challenges are never static. Those challenges are to respond to the evolution and the rapid progress which is being made in our societies. But when we talk about equity, we go back to the foundational values of our Constitution. We speak about excellence, our work ethic, both individually as judges and institutionally, as all of us put together. But above all, we also must focus in equity on social transformation. the social values which our work embodies every day of our lives. Because as judges, we have an equal role to play in the transformation of our societies. At a certain level, we come to court every day, we deal with those cases involving Order 39 applications, applications for bail and anticipatory bail, execution petitions, maintenance, and what have you not, claims for compensation under the Motor Vehicles Act. But there is something more fundamental which is going on in every case that we decide. And that in every case that we decide, we represent the quest for justice. And through justice, we seek to bring about a social transformation in the world around us. So make no bones about it that you, as key participants in the judicial process, have a vital role to play in the social transformation which is taking place not only in Karnataka, but across India and globally. I must appreciate that the themes for our conference are well curated and reflect several important issues that warrant larger discussion, including the issues and challenges in civil and criminal trials. I'm amazed when I learned of the statistics which Brother Justice Arvind Kumar put for you on the screen. As chairperson of the E-Committee, I also keep a watch on the statistics for disposal and institution. Between 1st of January 2023 to 23rd of March 2024, 21.25 lakh cases were instituted in the district judiciary in Karnataka. 20.62 lakh cases have been disposed of. So we are only short by a few thousand cases behind the curve. But across India, this is really a performance to replicate and to emulate all over the country. And therefore, I join the previous speakers in complimenting all of you, the members of the district judiciary, in the work which you have done. The government of Karnataka has also to be appreciated in terms of its constant support for the infrastructure and growth of the district judiciary. I just received a message from one of my colleagues, Justice Suresh Govindraj from the High Court, that the government of Karnataka has sanctioned 10 crores of rupees for e-Seva Kendras. Each of them will be 300 square feet at the rate of 14 lakhs per e-Seva Kendra. Brother Justice Bopanna highlighted a very important aspect, that in the march of technology, we should not leave any citizen behind, because there is an internet divide. The government of Karnataka has sanctioned laptops for all government pleaders and judicial personnel who man their litigation in the courts. But every one of our lawyers does not necessarily have a laptop or even a smartphone. Now, how do we ensure that technology does not leave anybody behind? That we intend to do by providing these e-Seva Kendras, in which every conceivable facility in terms of information and communications technology is made available to each citizen who accesses justice. I'm particularly pleased to see the inclusion of a session focused on work-life balance and stress management. The capacity to manage stress is significant in the life of a judge, especially for district judges. As judicial officers, you regularly engage with vulnerable litigants, many of whom look to you for justice. Many of the people who come to us are stressed about the injustice which has been caused to them. And sometimes in their dealings with us as judges, they cross the line. As Chief Justice of India, I see so many lawyers and litigants crossing the line when they speak to us in the court. The answer when these litigants cross the line is not to use the power of contempt, but to understand why they have crossed the line. There must be some deep-rooted injustice which they are confronting, which is why they sometimes say things which they do not otherwise want to say, as so many times happens within our own families. In these contexts, the responsibility you carry is immense, necessitating a calm and compassionate approach. Maintaining a work-life balance is integral to fulfilling these duties effectively. A judge who is overwhelmed with work and unable to prioritize personal time with family and self-care may struggle to perform optimally. Therefore, the ability to manage stress and achieve work-life balance is not separate from, but rather intertwined with delivering justice completely. They always tell physicians and surgeons, "Physician, heal thyself." Because before you heal others, you must learn how to heal yourself. The same is true about judges as well. You heal others. You bring peace to conflicting disputes and disputants. But you must first learn to heal yourself when you heal others. We live in difficult times. We live in times of the social media where work which we do is being constantly assessed. The Supreme Court of India has put all its important hearings on a live streaming platform, and we are watched all over the country. But we can also be trolled as a result of that. I'll just give you one example. Just 4 or 5 days ago, when I was hearing a case, I had a little pain in the back. So all that I did was I placed my elbows in my armchair in the court, and I just shifted my position in the chair. That video was doctored so as to delete that part of what followed thereafter. And there was a big amount of social media comment that the Chief Justice of India is so arrogant that he got up in the midst of an argument, an important argument in the court. What they didn't tell you was that all that he did was only to shift his position in the chair. 24 years of judging can be a little strenuous, as I have put in. But I didn't leave the court, I only shifted my position in the chair. But I was subject to vicious abuse, trolling, the knives were out. But I do believe that our shoulders are broad enough. And the ultimate confidence which we have is of common citizens in the work which we do. But I understand that this is the position of the Chief Justice of India. Judges in taluka courts don't have the kind of protection which we have. I've heard of stories where in my parent state, the state of Maharashtra, a young judge, Civil Judge Junior Division, is told by a member of the bar, "If you don't behave with me, I'll ensure that the High Court transfers you from this station." In other states, when I was Chief Justice of the state of Uttar Pradesh, the High Court of Judicature at Allahabad, there were some stories which I constantly heard every day about the manner in which young judges, middle-level judges, and senior judges were treated. You are blessed to belong to a state where these stories are only heard about and not witnessed during your day-to-day work. But I do understand the difficulties through which you travel when you do your work every day. Although there are points of convergence, most of the problems plaguing the district courts significantly differ from those affecting the high courts and the Supreme Court. In fact, given the plurality of experiences in our country, the issues faced by one district court are often incomparable even with the court in the neighboring district. In such a scenario, it is a methodology that we use to diagnose the problems plaguing our district judiciary, which assumes immense importance. The answer lies in comprehensive data collection and research. A famous American statistician has said, "In God we trust, all others must bring data." For a long period, our inability to address the diverse problems affecting the district judiciary arose from the lack of data on the cases, pendency, and infrastructural gaps in the district courts across the country. Today, the National Judicial Data Grid, or NJDG, acts as a comprehensive database, providing real-time data on district courts on an online platform. The NJDG works as a monitoring tool to identify, manage, and reduce the pendency of cases. We have set up the iJuris platform, which gives us a real-time evaluation of the infrastructure in the district judiciary. The Supreme Court, too, has several teams which are working towards institutional reform. The E-Committee of the Supreme Court and the Computer Cell have spearheaded several projects that seek to bridge this gap, using modern technology to improve the quality of data, its collection, and analysis to devise judicial reforms. The Center for Research and Planning of the Supreme Court is a team of officers and professionals. I have a woman judicial officer from the Judicial Service in the state of Haryana, and a host of almost 18 young lawyers who have been recruited for 2 years as law interns and law researchers from different states who have been deputed for the purpose of studying institutional challenges to the district judiciary. In November last year, the Supreme Court released a report on the state of the judiciary, a rigorous study of justice delivery efforts in high courts and the district judiciary across the country. The report covered 4 important aspects of the functioning of the district judiciary, namely judicial infrastructure, budgeting, human resource management, and the ICT infrastructure. Such rigorous data collection and research are essential to overcome the first obstacle to judicial reform at the district level, which is accurately ascertaining the situation across various states and identifying the problems. I'm hopeful that all of you in the audience today will actively engage with the various research-centric initiatives of the Supreme Court. By doing so, we cannot only bring the Supreme Court closer to you, but also contribute to the effective reform in the district courts. But there is another reason for data-driven policies. Our governments, the government of Karnataka is no exception, spend large amounts of money on the district judiciary. How do we justify the expenditure of public revenues on the Indian judiciary? How do we assess the impact of that expenditure which is incurred in our functioning? We must have objective yardsticks to assess what is our output, what is the quality of the work which we are rendering, and how different are we making the lives of citizens by the expenditure and investment of public revenues in the work which we do. One of the sub-themes of today's conference is women in the judiciary. I must highlight that the data with regard to the representation of women in the district judiciary is heartening and signifies tremendous progress. Across India, women constitute almost 37% of the working strength of the district judiciary. In particular, the data on recruitment of the district judiciary in Karnataka paints an optimistic picture. Out of the total working strength of 447 civil judges, 200 judicial officers are women, constituting approximately 44% of the working strength. Karnataka, in that sense, is leading the social transformation across India. Increasing representation of women judicial officers is crucial not only to correct a historic lack of representation in our courts, but also to bring diverse perspectives and experiences to the table, resulting in a more effective adjudication process. As I look into the audience, I can see a large number of women judicial officers present. Your contribution to the judiciary is of immense importance, and you serve as a source of inspiration for future generations of women aspiring to pursue careers in law and the Indian judiciary. An increase in the number of women judicial officers is undoubtedly an essential step to creating an inclusive and representative judiciary. However, a mere increase in the number of women is not sufficient. The next step is to create an atmosphere that is conducive for women judicial officers to carry out their functions effectively without hindrances and as equal participants in the justice delivery mechanism. Creating such an inclusive atmosphere requires active efforts from all quarters, the government, the High Court, and most of all, fellow male judicial officers as well. Our courtrooms, both in terms of physical infrastructure and in their effective functioning, were traditionally tailored to suit the realities of a biological man. There was a time when our district courts did not even have the facility of a separate washroom for women. Today, over 80% of district courts across India have a separate women's washroom. However, it must be highlighted that women have distinct sanitation needs compared to men, especially with regard to menstrual hygiene. Therefore, it is not enough to have separate washrooms. Such washrooms must also be female-friendly, providing for their unique sanitation needs. Only a meager 6.7% of district courts across India have washrooms that are female-friendly and have the facility of sanitary napkin vending machines. Almost 4 years ago, the Karnataka High Court installed sanitary napkin vending machines on the recommendation of my sister, Justice Nagaratna. Such initiatives must not be restricted to only our Supreme Court and the High Courts, but also spread to our district courts across the nation. It is the courts at the district level that act as the first point of contact for a woman litigant and serve as a workplace for thousands of women lawyers, judicial officers, and staff. We must not forget the women staff who are working in the district judiciary. They require these facilities equally with lawyers and judges. The conference includes a discussion on challenges in civil and criminal trials. Generally, constitutional courts are widely regarded as bastions that safeguard fundamental rights and ensure constitutional protection. However, I believe that the role and duty of district courts and judicial officers in upholding fundamental rights, such as the right to life and liberty under Article 21, is often far greater and more immediate than the constitutional courts. District court serves as the initial layer of protection for citizens entangled in the criminal justice system, guaranteeing adherence to proper arrest protocols, conducting medical examinations, ensuring dignified treatment, protecting rights against self-incrimination, and facilitating access to family and legal counsel. As you carry out your duties as judicial officers, this profound commitment to not only the letter of the law, but also the spirit of the Constitution must never be overlooked or underestimated. It's important that all of you provide mentorship to younger judges. Mentorship is not through only your administrative judges in the high courts. You must sit together as a team and encourage the younger members of the judiciary who are joining the fraternity. We are carefully looking at the service conditions of the district judiciary. As was mentioned a short while ago, under a direction and judgment of the Supreme Court, the second National Judicial Pay Commission recommendations were implemented with effect from 2016. What is the rationale for this? We are not a trade union of judges. The rationale for dignified conditions of service for our district judiciary is that our conditions of service define the independence and integrity of the judiciary. When our district judiciary knows that post-retirement they will be able to live in conditions of dignity, they will be independent in the work which they do today. Just 3 days ago, we had a case of a woman judicial officer, a district judge, who was elevated to the High Court with a small break. Her pension was fixed on the basis of her last drawn salary as a district judge. And she was told that because there was a break in your service, it's not your last drawn salary as a High Court judge which will determine your pension. She is in her 80s, I believe, and she's suffering from cancer. Look at the plight of somebody who has served the nation in the district judiciary, fighting at that age for the determination of pension. And in our judgment, we said that you cannot have this distinction between service judges who come to the High Court and bar judges. Bar judges are entitled to an addition of 10 years in the computation of their pension if they don't fulfill the qualifying requirement for pension. But on the other hand, a district judge was told that your pension will be on the basis of the last drawn salary. We said this distinction, the birthmarks between service judges and bar judges, has to be erased when you become judges of one institution. Medical treatment. We have provided in our judgment that we must provide cashless medical treatment for our district judges and for their dependent families, aged parents who depend upon them for support. But something very interesting was narrated to us by a team of district judges who are just in our court to observe the proceedings. They say, sir, it's very well to say that you will provide cashless treatment, but in many states in India, and I'm not speaking about Karnataka, I'm speaking as Chief Justice of India, in many states, the hospitals for cashless treatment are selected by inviting tenders. So the L1 bidder gets the contract. Now the L1 bidder always works on volume. So they will try and reduce the bid quoted so as to get the contract and then compromise on the quality of the treatment. So these are small issues, and therefore we directed that the high courts must constitute a permanent committee consisting of 2 senior judges of the High Court, the Finance Secretary, the Health Secretary, and the collectors of each district, so that you can identify those hospitals which are truly capable of proper treatment for our judicial officers. I'm thinking very seriously of career educational advancement for our judicial officers. Why should we not invite more and more judicial officers to curate postgraduate degree programs during the course of their service, so as to enable them to understand how the world around us is shaping and reshaping our lives? Before concluding, I would like to quote